Thank you, Josh. Happy to be here. My name is Toby Crouse. I get to do this all the time with who was then my dean, now became my friend. We do this probably 10 or 12 times a year.
And we're going to use a microphone. So I can say bad things about Steve now, and you can't hear it. So we get to do this from time to time, and you may wonder what a grown man is doing bringing a bobblehead up to the stage with me. This is a bobblehead of the Chief Justice, John Roberts. I didn't receive this from the Chief, but I did receive it from Steve. And the reason I'm doing so is there is an outfit called the Green Bag, if anybody's familiar with it, that I think is somewhat of a quirky academic Supreme Court, just kind of a neat quarterly magazine. And they do these bobbleheads in which if you're a subscriber, you get notice, you can go to EC Law Firm, you can pick up your bobblehead. Steve was kind enough to get me a bobblehead of the Chief, so it's in my office. And I'm minding my business as I typically do, just on a daily basis. And I see on my Twitter feed that the Green Bag has announced its latest bobblehead. And without further ado, I'm going to read what I received. The best and the bobbliest, Steve McAllister. We have news of another pillar of law who has yet sat on the U.S. Supreme Court, although he has argued many cases there, but has already achieved immortality as a bobblehead, Stephen McAllister. So this is my public plea to get the next Steve McAllister bobblehead, and if you are a Green Bag Institute person, go get yours. So with that frivolity out of the way, congratulations, Steve. It is a great honor, and I do like making fun of you, but it's a wonderful honor. This goes out to all of the folks who really are terrific lawyers, and I commend you. So with that, we do this, we kind of go through what the cases are for this current term. We'll probably change it up a little bit today, maybe preview some of the cases for the next term that are coming on, talk a little bit about Kansans in the court, the recent confirmation process, maybe offer unsolicited opinions as to what, if any, next confirmation process is coming. And then a couple of cases that are not on your list, and I believe, since I emailed Josh the presentation this morning, none of you have our written materials, and so it would be wonderful because you can't pay attention to what we're saying. So we'll talk about those cases, and I guess with that, I'll hand it over to Steve, and then eventually we'll get to the cases on the list.
Yeah, right. So what do you want to talk about first? Well, I would say a couple of things about this term. A very, very slow term, obviously.
First, talk about your bobblehead.
Well, that bobblehead is actually a credit to my wife. So she is the one who created that bobblehead. So you'll never get one unless you talk to her. So
that's fair.
Yeah, and my kids all have one in their room staring at me. So
do we have this one? You have this bobblehead?
We have
really?
one, yes.
Here's what it looks like. It's awesome.
So, but this term, you know, with the death of Justice Scalia in the sort of presidential election, we went quite some time with only 8 justices, and that makes a big difference at the court, almost no matter the circumstances. I mean, for one thing, as divided as they are on a lot of big issues, they didn't take much that was at all interesting. Tons of statutory cases, if you like patent, you like little statutory interpretation, you're really into the Fair Debt Collection Practices Act, things like that the court took this term. Not a whole lot on the constitutional front, but I think that's already starting to change with Justice Gorsuch. So they granted a case this week that I think is a very, very big case on the political gerrymandering, depending on what they decide to do. If the court decides to get involved, it will be a huge case. If they decide to stay out like they always have, then the status quo will be maintained. We'll see if we can talk about that one. But I think it really affected their dynamic. So, you know, Toby and I struggled a lot this term. There are some things of interest to talk about, but it's not a blockbuster term by any means. And I looked last night, and I think there are something like 58 opinions they have issued this far. They're almost at the end, but 6 of those are per curiams, where they didn't have oral argument. They just got the cert papers, decided some lower court was really wrong, and reversed it per curiam. So really 52 signed opinions at this point. It's going to be one of the smallest terms they've had in a long, long time, perhaps ever. So they're not doing as much but that will change, I think, with Justice Gorsuch now on the bench. And how will he change things? I don't think a lot. He's not obviously known as Justice Scalia. Justice Gorsuch will have some work to do to fill those shoes, but philosophically, there's a lot of similarities between the two. I think on a lot of issues, it would have been 5-4 with Scalia in the 5. It will be 5-4 with Gorsuch in the 5. Maybe not everything, but most things. What I will say about the judge, though, is if you've ever been in front of him or around him, he's incredibly smart and articulate and insightful. He's going to ask very hard questions in oral arguments. Unlike Justice Scalia, I think Justice Gorsuch is likely to be diplomatic all of the time, and perhaps not as crusty as Justice Scalia could be at times in oral arguments. But he's a very, very bright fellow, and I think we got a great one when he got nominated and confirmed. And it also means that the court we've known for the last many years is really still our court. And I was prepared after Scalia died. If it had been Merrick Garland, who's by all accounts a very credentialed fellow, it would not have been the court I've had most of my career with. It would have been starting to change on some very important issues. I don't think that's going to happen now unless we get some surprises. And that's a question of who might retire or be the next to go. Ginsburg won't quit voluntarily under this administration. I don't think Breyer will either. So the question might be Kennedy, in which case there could be a real battle to try to fill that seat with someone more consistently, perhaps conservative than Justice Kennedy. I don't know what would happen in the Senate.
Yeah, Steve has a far better touch on this than I do, but I do hear rumors and gossip that the Trump administration was publicly and privately trying to make Justice Kennedy feel comfortable to resign. I think the timing would work out well. If somebody's going to resign, it probably needed to be in June of this year, whether June 1 or June 30. You kind of need to get that process started, because if you let this slip into the next term, you've got midterm elections, who knows what the Senate's going to look like. They've got a 52-48 split right now, so I think they have to look at that. I think the political gerrymandering case is an interesting one that the court took, and it may impact Justice Kennedy's willingness to the extent he was willing to consider resigning now. I think that probably makes it more likely he stays. I had heard rumors of discussion, and Steve would certainly know better, whether Justice Thomas wants to get out, go travel the world in an RV. But I think if that's going to happen, it probably needs to happen this year for the legislative calendar to work, because you just don't know what's going to happen in midterms. I think that's, I don't have any other speculation other than, yeah, let's talk about a little bit about the case that we didn't have. We want to talk about the gerrymandering case. And so Monday there were a couple of cases that got kicked out that I think are interesting. I did want to talk about the first Judge Gorsuch opinion. It was a boring case, Henson versus Santander, the Fair Debt Collection Practices Act. Typically we will talk about Kansas at the court, and Steve has primarily been arguing for Kansas at the court, so usually we have a good Kansas connection. This year we really don't. The closest we've got is Ken Shanmugam. He argued Henson versus Santander and won Justice Gorsuch's first opinion. If you are a fan of Justice Gorsuch's writing, you like contractions, and you like snappy discussions, it's pretty interesting. The first sentence in his first decision started off, disruptive dinnertime calls, downright deceit, and more besides, drew Congress's eye to the debt collection industry. So he started off with that. I'm not sure what "and more besides" means. He used it twice in that discussion. Contractions throughout, very conversational tone. For those Federalist Society folks among us, the latter part of his statutory discussion was straight out of his confirmation hearing, what judges are supposed to do, how they're supposed to interpret statutes. If you don't like the way the court ruled today, Congress, you may go in and change the result. That's a very consistent with the testimony he gave before the city commission. So I think the most shocking thing about it was he continued using contractions. If you've read his 10th Circuit decisions, kind of shocked me the first time. I wondered what my old boss would have thought the first time she saw those contractions at Judge Gorsuch, and he kept them with the Supreme Court. So I think that's no. You want to talk about maybe gerrymandering?
I'll talk about the one that they just granted money that I've mentioned already. So they've got a gerrymandering case out of Wisconsin, and the court's had a lot of gerrymandering cases involving race, and with race is taken into account in drawing district lines, and they're just almost every term it seems like there's something in that category, and there's an equal protection basis for saying race is special here. We should take that into account, but also we've got to police how states do that. Well, the case they've got now is based on what's called political gerrymandering. So the Republicans are in charge, it's time to redraw the lines, they draw them in their favor and to the disadvantage of the Democrats. The Democrats are in charge, it's time to redraw the lines, they draw them in their favor and to the disadvantage of the Republicans. Shocking, isn't it, that that goes on? So the question is, in the Wisconsin case, is there anything the courts can do about that? And the Supreme Court had a case about 13 years ago, Pennsylvania, called Beef. And it's a great Scalia opinion, but it's a plurality. So Scalia and three others who say, good grief, what are we supposed to do with this? There's just no judicial standards we can develop and apply here. I mean, you're not even talking about a mutable characteristic. I mean, you can be a Republican one day and an independent or a Democrat the next. You can change your affiliation. This is not race or that sort of thing. And so 4 justices said, we should just stay out of it. It's not justiciable. There's nothing for us to do here. We'll just make a mess of things. Justice Kennedy, Toby's point, was the 5th vote. And he said basically, yeah, I don't see a standard here, but maybe one will come along one day. So I'm not going to say never. I just don't see it yet. So now he's going to have his chance 13, 14 years later to see if he can find a standard. And then I teach this class in common law and always have fun with it, because then I think you have the 4 dissenters with at least 3 different proposed tests of their own. So you've got 4 justices who say there's no test we can come up with, 1 justice who says there might be a test someday, I don't know what it is or if it'll ever appear. And then you have Justice Stevens has a test, Justice Souter has a test, and Justice Breyer has a test, and they're all very different tests. So that's the case that's in front of them now. Is there something here for the courts to get into and try to police? And even if you want to say yes, the very, very hard question, I think, is what is your standard? When is political gerrymandering going too far so that it's unconstitutional in some sense? And the challengers in Wisconsin have proposed a test. I haven't studied enough to fully understand it, but it's basically a mathematical calculation where they try to figure out what they call how many wasted votes did the Democrats have, how many wasted votes did the Republicans have, and then they divide it by some number and they come up with a ratio. I mean, maybe that's a test, but I have a hard time seeing how you get that out of the Constitution somehow. So in any event, that's going to be a bit for the court, and very well, given Beef, if people fall into line as you would expect, it will probably be 4, and Kennedy in the middle, seeing if he's convinced or not. There's a test that the court can apply in this setting. So that'll be, if he says no, and the answer is nothing for the courts to do here, then it's business as usual. If 5 say there actually is a standard here, find out what that is, but it could impact all states across the country in terms of the way redistricting works.
Yeah, a couple of things on that. There were a couple of folks in the room that were involved in the redistricting last time. I think Kansas will play an interesting part in this. I sent Steve the Adam Liptak article last night. I think there are 10 states in which this ratio which show that there are too many wasted votes. I think the concept of blocking and cracking, where you either block it,
Packing, correct.
packing, that's right. So you pack the Democrats in one group, or you split them up so that their votes are diluted. And that ratio comes out. There are 10 states, one of them including Kansas, in which this is done. So I think Kansas generally will probably have a prominent role. Perhaps even, well, no comment. I think the AG's office here may have an interest in that case that will come up. And so we'll see how that goes. The other concept that I think will be interesting is the court granted a Fourth Circuit or a Fourth Amendment case on cell phone historical tracking sites. I think that was 2 weeks ago, in which case whether the DOJ needs a search warrant to go get historical cell data sites. Does that violate the Fourth Amendment? There's been a lot of scholarly discussion on that concept, so the court's going to take that. I think the next term is going to be pretty entertaining. It'll get back to the more blockbuster type cases. Anything else to go for? All right, so I guess we'll talk about the cases generally from your list, which you don't have. Trust me, it's a great list. All right, so the first case I'm going to talk about is a First Amendment case, and I call this the Paula Deen case. And I would be remiss if I did not mention another case. I have many faults. One of them is that I like the Redskins because when I was a kid, Jim Theismann and John Riggins and Art Monk were my heroes. And so the current owner of the Redskins, as you may know, has done nothing to the football team except save the logo. So my childhood team still has its logo. 2 or 3 years ago, I believe it was, there was a movement to get that logo stricken in the Patent Trademark Office, said it was an offensive logo, so they struck that down. That looked like the end. I bought my last Redskins hat. I was pretty happy and sad to see the logo go. But unbeknownst to me, there's a band called the Slants, and they come out with their name. They're an Asian group, what type of music they play, but their name is the Slants. They were denied that trademark on the name because it was deemed derogatory. Slants. Simon Chapel, I guess that's how you pronounce his name, said, well, yes, it's offensive. And we picked it because it's offensive. We want to take the power out of that offensive name. So that issue goes up to the Supreme Court. And that issue was whether or not the government has any business regulating private trademarks or private entities. Is that government speech that becomes offensive when the government says it, or is this private stuff that should stay out? The good news for my Redskins is the court came down and said that's purely private speech. The government doesn't have any right to take that away. So that's just somewhat of an aside. That was issued on Monday, which I call it First Amendment Monday, because the Paula Deen case was also issued on Monday. Packingham versus North Carolina. This is an entertaining case because it comes out of North Carolina and it involves Paula Deen. So let me set the stage for you. There is this bad dude named Lester Packingham, and when he is 21, I think he's 21, he decides to have sex with a 13-year-old girl. Just doesn't have sex with her. He doesn't use the internet to find her. He met her someplace. So he gets convicted of that. He's now a sex offender under the state of North Carolina's laws, and he has to register under sex offender notices. The North Carolina legislature said, you know, what we need to do is, the internet is a powerful forum, and we need to limit sex offenders from how they access the internet, how they use that as a tool of terror, so to speak, against the minors and the youth of America. They can pretend that they're a 13-year-old girl, try to meet at the local mall or whatever, or take them, things like that. So we need to preclude these sex offenders from getting access to social websites. And they passed a law that had 4 aspects. That law said that if the website is operated by a person who derives revenue from membership fees, pretty much all of them, if it facilitates social introduction between 2 or more people for the purpose of friendship, again, not many that don't. 3, if it allows users to create web pages for personal profiles, and has one of those emoticons of your picture, again, most of them. And 4, if it's provides users mechanisms to communicate with each other. So there aren't many websites these days that don't fit that category. Things that come to mind: Twitter, Facebook, New York Times, commentary section of your local newspaper. Pretty much everything that you do, or at least that I do on the web, has some functionality that would fit within this law. So our good friend, Mr. Packingham, he is subject to this law. He goes out and he gets a speeding ticket. But when he goes to court, it gets dismissed. And like any good 2017 or 2014 individual, he gets on Facebook to proclaim his good news. And he writes, "Man, God is good. How about I got so much favor they dismissed the ticket before court even started. No fine, no court costs, no nothing spent. Praise be to God. Wow, thanks Jesus." So that's what he says on Facebook. Seems pretty offensive. Of course, so we've got a law enforcement officer with nothing better to do than troll Facebook pages, and he finds that this Gerald Packingham made this proclamation. He says, "Well, I think Gerald Packingham's a sex offender. Let's look that up." Sure enough, he is. They go prosecute him under this North Carolina statute for participating in these online posts. That goes up to the North Carolina Supreme Court. It's challenged by Mr. Packingham, who says this violates my First Amendment rights. I can't even go onto Twitter or the New York Times to read about my case. You're precluding me from a broad section of, conduct today. So that goes to the North Carolina Supreme Court. They balance. The state has a huge interest in protecting individuals within the state from online predators. They go through a parade of horribles of things that can happen. And at the same time, it really isn't that big of an imposition on Mr. Packingham, according to the North Carolina Supreme Court. For example, if he wants to get his news, he can go to the local TV station's news site, WRAL.com, and he can get his news. They preclude anybody under the age of 18 from signing up. What's so wrong with that? And oh, by the way, if he wants to interact with like-minded folks, he can go on the Paula Deen Network, who also precludes people under the age of 18. So he can get his social interactions from Paula Deen. That goes up to the Supreme Court, and not surprisingly, oral argument and the decision did not exactly go in the North Carolina Supreme Court's way. The Supreme Court, Justice Kennedy wrote a decision that ended up being an 8-0 for the result, but the rationale is a little bit different. In Justice Kennedy forum talks a little bit about how broad First Amendment protections are, how the tools of the trade, even the railroads when they first came out were used as a means of facilitating crime. Criminals are always going to find a way to do this. But the internet is like the public square of the days past. And therefore precluding him literally from all of these websites, Facebook, Twitter, WebMD, all of these things was just too much. He's not saying that it's unlawful for states to restrict how much sex offenders can get on websites, just that this law was too much. One might think that would be universal, but Justice Alito did not like that. He wrote a concurrence in the judgment and said, "I cannot join the opinion of the court because of its undisciplined dicta." That's pretty strong language for Justice Alito. And what he's talking about is that the court effectively creates a no-fly zone in which state court legislatures can go. That's Justice Alito's concern. I think it's debatable whether that is so broad, but that was certainly Justice Alito's thoughts. He concludes with, "Like the court, I find it unnecessary to resolve the dispute because the law in question can't satisfy the particular test here. Only make it a narrow ruling that this law is too broad." So I think that's the breadth and the scope of states to restrict internet freedoms will come back to the courts soon and probably frequently. The other thing that I think is interesting is Justice Kennedy relied significantly upon Nika's brief and what people's using habits are and how they use the internet and the freedoms that people associate with. So just unusual in the judgment and evidence and all of those things to rely upon Nika's brief.
Yeah, well, anytime you have a First Amendment speech case going to the court, you're always better off if you're the person asserting the speech right. The court rarely uphold speech restrictions. You know, Alito's one of the few who might, but he's been on the short end of cases like the Phelps case or the Medal of Valor case and those sorts of things. Well, I'm going to talk about First Amendment, but not speech. This, I think, has the potential to be one of the really important, it's kind of a sleeper perhaps, but perhaps a very important case. It's called Trinity Lutheran. It comes out of Missouri, and it's about religion. And so Missouri has a program where to recycle tires, they grind them up into little pellets, and then they have people apply if you want a big pile of this stuff. And apparently what you use them for is you serve as a playground. So if the kids fall, it's a nice rubbery soft surface. So you apply, and Missouri decides who's worthy, and then if you're worthy, you get a bunch of ground up tire. Well, Trinity Lutheran is a Lutheran daycare, a preschool, and their playground apparently had pea gravel on it. And they wanted something softer, so they applied, and they actually finished pretty high up in the, there was like 50 some applicants, and they were maybe in the top 10 or so. They would have qualified to get some of this material from Missouri. But when it came time to deliver, Missouri officials said, well, you know, actually, we cannot give you any of this. You cannot participate in this program because you're a religiously based entity. And the Missouri Constitution has a very strong form of something called a Blaine Amendment. Let me talk for just a minute about a Blaine Amendment. So Blaine was Speaker of the House, U.S. House, post-Reconstruction. So the latter part of the 19th century, he, by all accounts, was probably pretty anti-Catholic. He proposed a federal constitutional amendment that would have said basically no public money can go to religious entities in any fashion. It did not pass at the federal level, but the states picked it up. And about 3/4 of the states in their own constitutions have some form of a Blaine Amendment. And these things are sometimes, and Missouri is a good example, very strongly worded about no public support, no funding going to a religious entity for any purpose, under any circumstances. Kansas has a little piece of one. It actually shows up in Article 6 in the education article, maybe Section 5, I'm not sure, but it's in one of those that basically says no funds going to non-public schools, but it doesn't have a full-blown Blaine Amendment like Missouri does, which says it doesn't matter what the program is, schools or anything else, no support, no money to religious interests. So Missouri said, you can't have it. We can't do it. It would violate our state constitution to let you participate in the program. So the preschool sued and argued equal protection. You're treating us differently because of religion than everybody else. And they also argued free exercise, that you're basically restricting and punishing our exercise, the fact that we're a religious organization. This is a non-religious program, non-religious purpose. This is for safety of the kids. What's the big deal? But the lower federal courts upheld Missouri's decision, and so it's gotten to the Supreme Court in the posture of Missouri does not violate the federal constitution by denying participation of religious groups in programs like this. And so that was argued, actually, it was ready. This is an interesting one, because it was ready months ago. It probably could have been argued as early as January. But the court just kept doing nothing. People were watching, and it didn't show up on the argument calendar, it didn't show up on the argument calendar. They get Justice Gorsuch, and it's on the April calendar. So he's actually participating in this one, and I suspect what that tells us is the justices, at least, if not were certain, were pretty strongly of the view they were going to divide 4-4 if they didn't have a ninth justice. Well, so now they've got Justice Gorsuch, and what does that mean? I think it probably bodes well, actually, for the religious challengers. There was a lot of discussion at the oral argument, you know, what's the risk here, what's the threat? You know, the state's saying, well, we don't want to have connections with religion, you know, establishment clause kinds of concerns, but the counter to that is, well, but you've gone beyond neutrality, and you're actually being effectively hostile to religious interests. When anyone else can participate in these programs, but if they have a religious connection, they cannot. That's just too far. And the reason I say this could be a very important case is if the court in fact says that Missouri cannot deny participation, then it's at least started making inroads on these Blaine amendments, which are out there in 3/4 of the states. And there's been a fair amount of litigation across the country under the state provisions because they are so much more strict and specific than the federal First Amendment religious protections, which are just a few words, both free exercise and establishment. So if Missouri loses, which I think it may well, I think Justice Gorsuch is likely to be on the side of the religious challengers here, then it could have significance for state Supreme Courts and states across the country that have these Blaine amendments in their state constitution. So that's one to watch for. Argued in April, we're now, June 21st, so within the next week, we'll probably get an answer on Trinity Lutheran.
I'm going to talk about two cases that one of them is on your list. The Supreme Court has taken some business cases this term. I'd like to talk about Microsoft versus Baker, which is on your list, and I think while I didn't get it printed off, I think it was decided earlier this month. But I'd also like to talk about a case that was decided, I think it was Monday, on the First Amendment. So I guess it's not really First Amendment Monday, there's other things going on. Bristol Meyer versus Squibb. Anybody CNBC fan? Who's the guy who's Bristol Meyer? So I want to say that every time I say it. Bristol Meyer Squibb is about specific jurisdiction and is likely to have, at least for business litigators, a massive impact on litigation. In St. Louis County, it's already happened. It deals with whether or not companies can be sued in states in which they really don't do a whole lot of business. I think it was 4 or 5 terms ago, Daimler Chrysler came out and said you can sue under general jurisdiction if the defendant is effectively in that home state. Otherwise, you need some contact to the defendant as a plaintiff. This comes up, it was, I believe the plaintiffs were prescribed Plavix, and some of the plaintiffs were from California for sure. Most were not. They evidently deemed that California was a great place to sue. Bristol Meyer really didn't have any impact or connection to California, but because the Ninth Circuit said that there is specific jurisdiction, which Justice Alito called a really loose and interesting interpretation of specific jurisdiction, they were allowed to be sued there. This also happened, I mentioned, in St. Louis County. There was a talcum powder case. I believe Johnson & Johnson got hit with $92 million for largely with out-of-state plaintiffs, which is before either the Missouri Court of Appeals or Supreme Court. So that happened. There was also a trial going on that, as of yesterday or the day before, in light of Bristol Meyer, was dismissed. So I commend that to you. Won't talk about it a lot, but I think it's likely to have impact, certainly for the mass torts or the big cases. Moving to Microsoft versus Baker, it is a class action case that is of particular note to Microsoft. They did something with the Microsoft Xbox. Somebody didn't like it. Their claims were very small, so they pulled everything together, tried to get a class action certified. They went through class certification proceedings, and the district court said, no, we don't think that this is a sufficient class in which to go forward. I'm denying your class certification, but each individual plaintiff can continue to go forward. And the individual plaintiffs were like, well, our claims aren't that big, plaintiffs' lawyers don't want to go forward. So they struck an agreement with Microsoft to dismiss with prejudice on the condition that if they win on appeal, they can come back. So they're effectively getting a free appeal. This is again, a Ninth Circuit issue. The Ninth Circuit said, yeah, that's fine. We'll take that as a final judgment. We'll let them go forward. That came out, Justice Ginsburg, I believe, is who wrote it. I just looked at it. Take my word for it, it's Justice Ginsburg. She wrote a great thing. So she said, no, this is not appropriate. The framers of the Rules of Civil Procedure created, I believe it was 23F. They have procedures in which someone who's denied class cert to the Circuit Court of Appeals and asks for permission. There's a judicial discretion there. this is the proper balance that the framers of the rules of civil procedure struck. Under the old death knell doctrine, or under this voluntary dismissal, the plaintiffs were the only ones controlling when the case was appealed and how it was going to be appealed. She expressed a lot of concern that there was piecemeal litigation. Who knows how many appeals are going to go forward, and ultimately impacted or said to follow the procedures in the rules of civil procedure. I also think this case is interesting, and it may have some impact in the nationwide injunctions that are being issued. Like last term, there was the immigration order of Texas. I believe the state of Kansas got a nationwide class action or a nationwide injunction under the last administration. You've seen the travel ban. There's been nationwide injunctions. I'm going to be interested to see whether the same uncertified class nationwide injunctions are how they're treated under this rule. Should they be treated like a class action? It's one thing to enjoin the government for vis-a-vis Steve, but for all of the people who are like Steve, to enjoin that, whether it's a universal injunction or just an individual injunction, I think we'll be interested. So that's, you may have a point.
Now I'm going to talk about one that was decided Monday, and it's, I'll try to strip it down to its essence. It's basically a gender discrimination case. It's called Lynch versus Morales-Santana. So the issue is, how do you get citizenship if you have unwed parents, but one of them is an American and the child is born abroad? So the child is not born on U.S. soil, the parents are not married, one of them is an American. Well, in 1940, Congress said, well, if the mom is the citizen, then we will require that she have lived in the U.S. for at least 1 year at some time prior to the child's birth. But if the dad is the citizen, then he has to have lived in the U.S. for at least 10 years prior to the birth, and at least 5 of those years have to be after he was age 14. Now, what's the rationale for the difference? It's not completely clear, but I think a lot of it was probably gender stereotype. The unwed mother, of course, is going to be connected closely to this child, so if she's an American citizen, this child is going to understand and want to be an American citizen. But if the dad is a citizen and the mom is from some other country, well, then we need to make sure the dad is really connected to America, because the mom may be pulling the child to become a citizen of some other country, something like that. But in any event, it comes up here, as it usually does in these cases, when somebody gets in trouble for crimes, they get convicted, and it's time to deport, and they say, well, wait a minute, I'm actually a U.S. citizen. And that's what happened here. And the father was the citizen, and he had not lived apparently in the U.S. He lived in the U.S. for many years, but he had not lived more than 5 years after age 14 growing up or something. In any event, the child did not qualify under the statute. And so the question was whether that's unconstitutional gender discrimination. Well, all I have to tell you is who wrote the opinion, and you know the answer. Justice Ginsburg writes for the court. And there's kind of a couple interesting questions. One is, well, it's actually the kid who's complaining here, but the statute is based on the status of the parents. So it actually treats the parents differentially, not children. So they said, well, does he even have standing? And they pretty easily say, well, who else would really care or assert the claim? It's close connection. We'll let him have standing. And then it's a pretty easy call for the court to say, what the heck? You know, why this difference? If anything, it's based on gender stereotypes of the 1940s. It certainly doesn't seem to have any strong government interest behind this distinction. But what I find in some ways most interesting about the case is the court says, well, so now what do we do? So it's a violation to treat this differently if the mother's the citizen or if the father's the citizen. But how do we fix it? What's the remedy? And of course, the challenger was arguing, well, just let everybody have the rule for mothers. Just have to be in the U.S. 1 year prior to birth. And the court actually said, well, not so fast. And you think about it, equal protection cases, people are being treated in different ways. There's two ways to get back to equality. One, the most common, is to level up, to bring up the group that's being disadvantaged so they get the same treatment. But it's still equal protection if you level down. So the group that's getting, in a sense, the advantage is brought back down to the disadvantaged group. And that's in fact what the court chooses to do in this case. So they actually say, well, we think the general rule, in the 1940s, they would have been pretty restrictive about citizenship. They would not have wanted it to be easy. The 1 year for mothers, that was an exception to the general rule. And in fact, the stricter rules for fathers is the general rule. So we're going to take away the mother's exception. And so now everybody is subject to the harsher rule. And I think what the court is really trying to do is put the ball on Congress to figure out what the heck should the rule be here. But for the time being, it's the harsh rule. So this guy won the case, but he sort of won the battle, lost the war. So he got him to agree there's a constitutional violation, but they adopted the rule that he can't satisfy. So I think he'll be on his way at some point here.
Josh, how are we doing on time?
Are 3 minutes, 3 minutes.
All right, so I'll talk quickly about a case that is not in the materials that you do not have. County of Los Angeles versus Mendez. The reason I'm doing so is it impacts me, and after all, it's here for me. So I represent a lot of sheriff's departments, and I've got one of them in which they shot a young man multiple times, but they thought he had a gun. And so the typical claim would be a Fourth Amendment case. And the question is whether it's reasonable. Is it reasonable for officers to shoot an individual with a gun? Well, that's typically not a difficult discussion to have. It's pretty reasonable. I think most of us, whether we're law enforcement or not, believe the use of deadly force is appropriate. And that's the Graham versus Connor Fourth Amendment test. The cops are always going to win there. Entrepreneurial plaintiffs lawyers have looked for a couple of ways around it. I think it was 2 terms ago in County of San Francisco versus Sheehan. There was an ADA claim saying that the officers, the person that they were addressing had a weapon. They didn't give her the proper accommodation. And the court took that, looked at it, and largely punted. And so that issue and concept is still out there. I will tell you the 10th Circuit is not entirely foreclosed, but it's out there. It's unlikely to succeed. But this one is the danger creation doctrine, which is the second way to get around it. And that is, well, sure, it may have been reasonable for you to shoot the individual who pulled a gun on you, but look at what you did to put them into the situation that caused them to shoot you or to pull the gun on you. And that's what is going on here. It's called the provocation rule in the 9th Circuit, 10th Circuit, and many other circuits have, it's called the danger creation doctrine. And that issue came up in Mendez. I won't go into the details of it, other than to say that officers busted into a hovel. A man and a pregnant woman were in there. He grabbed a BB gun. He and she both got shot multiple times. The 9th Circuit said, well, it was reasonable for the officers to shoot him. So there's no Fourth Amendment claim. But they provoked him to shoot him by barging into their hovel, and therefore we're going to allow liability to go forward. Pretty easy 8-0 reversal on that. I think it will have impact, at least on my line of work. And we'll see what the ADA is going to do. Anything else you want to talk about before Josh takes us off stage?
Ready for us? We're good.
Josh, are you good? Oh yeah, any questions? So Steve, would anyone like to ask Steve questions?
I've got one.
Yep.
Way over here on the fringe. I guess it's evidentiary and then procedural. Prediction. Candidates' pre-election statements as evidence of what? And then how does that case fall, if we're thinking about the same case, since it's late in one term and pretty early for the second term, and we're all going to be waiting on, you'd think it gets some kind of fast track. And that's the Hawaii, Trump, or whatever style it's going by.
Yeah, I mean, that issue is headed to the court. I sort of assume they will take it. I mean, they could punt and dodge it, but sort of assumed they would. It's a very fair question. It's a strange situation to say, well, somebody said something months ago on the campaign trail. They weren't even in the office. And then they issue an order that we're going to invalidate because of what they said on the campaign trail. That's not a typical way of approaching executive orders. And in fact, there's been some discussion in some of those cases in the oral arguments by some judges, I think, who are sympathetic. Basically, to the plaintiff saying, are you telling me if this order had been issued in the abstract and you wiped away that history, that this would be okay? And the answer is maybe yes. So, the challenges are really relying not on a lack of executive power, but on proof of what they think is an unconstitutional motive. And I think that's potentially a dangerous direction for courts to go if you're going to start using that as a means. It ought to be about the power of the office and the power of the official, and do they have the authority to do this, in my view, and not let's invalidate it because we're not sure about their motive. Because I just think that's dangerous, and it's going to get the courts very tangled up in political disputes.
And then what about the process? I think the time for the appeal from Ninth Circuit's on now. I think isn't there a Virginia case?
There's a Virginia case that I am not sure, but I thought one of them, maybe the U.S. has just said we are going to seek review. I thought one of them, maybe the Fourth Circuit, had actually, as a petition had been filed by the U.S. asking for review, and of course then there's time for the other side to respond. It'll take a little bit here, and then they go into summer recess, so they may not actually make a decision until late September, but they'll kick it up. My guess is the Supreme Court is not going to be eager to expedite the process, but in the ordinary course, if all goes as it usually does, and they do take it in late September, then you're probably talking about an argument first of next year, and certainly a decision within the next term.
For what little it's worth, I think it's interesting using what I would consider extrajudicial statements. I've been in a case where the legislator's statements were used against them and then not allowed in the 10th Circuit. I've also seen cases in which the legislator's statements during the debates are allowed. And so I think extending that to the executive power issue is, for a law nerd, I think that'll be an interesting question. There are obviously practical issues that people will be more concerned with. But I do think it's interesting whether you're going to use the extrajudicial statements.
Let's wrap it up there. Thank you to our panelists.